I'm the Registrar Clerk for this matter, Acting Deputy Chief Justice of the Constitutional Court. I call the matter of University of Johannesburg and Auckland Park Theological Seminary and another for judgment. Counsel are now invited to place themselves on record. Please note that this judgment is being recorded.
As the court pleases. Good morning, Justice Kampembe. My name is Nokolo Kumalo. I confirm my appearance on behalf of the applicant in this matter.
Thank you, Ms. Kumalo.
May it please the court, Acting Deputy Chief Justice Kampepe. My name is Jerry Stein of the firm WP Stein Attorneys. I represent the first and second respondent in the matter.
Thank you, Mr. Stein. Today, the Constitutional Court hands down judgment in an application for leave to appeal against a judgment and order of the Supreme Court of Appeal. The Supreme Court of Appeal overturned a decision by the High Court to accept evidence of context brought to show that rights in a lease were personal in nature and therefore incapable of cession by virtue of the delectus personae concept. It held that the words of the lease were unambiguous and had to be construed objectively, and that the evidence accepted by the High Court ought to have been excluded by virtue of the parole evidence rule. The central question before the Constitutional Court was whether evidence of context can be brought to show that rights in a long-term lease are personal in nature and therefore incapable of cession by virtue of the delectus personae concept. The dispute between the parties arises from a long-term lease entered into between the applicant, the University of Johannesburg, hereafter referred to as UJ, and the first respondent, Auckland Park Theological Seminary, hereafter referred to as ATS. The lease was entered into for the purpose of ATS using the leased land to build a theological college. In terms of Section 4, subsection 2 of the Rand Afrikaans University Act, UJ obtained permission from the Minister of Education to lease the land to UJ. The application to the minister referred to ATS by name and specifically indicated that ATS required the land to build a theological college, a project in which UJ wished to assist by providing the land. The minister granted permission on 18 June 1996, after which the parties entered into the impugned lease. The lease was to endure for 30 years, renewable with 6 months written notice by ATS. ATS paid a once-off rental of 700,000 rands. As it turned out, however, ATS did not establish a theological college on the land. Instead, it ceded its rights under the lease agreement to the second respondent, WOMJ, after WOMJ paid ATS an amount of 6.5 million rands for the rights. It is common cause that WOMJ's intention was to establish a religious-based school for primary and high school education on the lease premises. It is also common cause that neither ATS nor WOMJ notified UJ of the session, nor did they seek UJ's permission or ministerial approval. When UJ came to know of the session, it took the view that the rights in the lease agreement were personal to ATS and that ATS had therefore repudiated the lease agreement by purporting to cede the rights to WOMJ. UJ then purported to accept ATS repudiation and cancelled the lease agreement. The respondents disputed UJ's right to cancel the agreement. This dispute led to UJ approaching the High Court for orders evicting ATS and WOMJ from the lease premises and cancelling the registration of the lease against the title deed of the land. The High Court undertook a contextual interpretation of the lease agreement and Clause 8 in particular, and held that UJ had made out a case that the lease was delectus personae. It held that the evidence of the context of the lease was consistent and uncontroverted in relation to the personal nature of the relationship between UJ and ATS. The High Court therefore granted the relief sought by UJ. The respondents appealed to the full court. The majority of the full court dismissed the appeal with cost. The majority held that the reasoning and findings of the High Court on the personal nature of the lease could not be faulted, and added further reasons which pointed to the conclusion that AT's rights under the lease were delectus personae. Although the minority judgment differed in its approach, it too would have dismissed the appeal with costs. Dissatisfied with the decision of the High Court and the full court, ATS and WOMJ approached the Supreme Court of Appeal. The Supreme Court of Appeal quoted with approval the statement from Bishop versus Theron that in a long-term lease, the lessor does not expect that the obligations of the lease will be carried out personally by the lessee throughout the whole term, and that there is therefore ordinarily not delectus personae. The Supreme Court of Appeal held that this was true of an urban tenement, and that a lessee can therefore cede its rights under a lease without the consent of a landlord, unless the terms of the lease forbid it from doing so. The court held that in this case, there was nothing in the lease itself which indicated that ATS rights were not intended to be ceded. It said that UJ had sought to meet these difficulties by adducing oral evidence. However, according to the court, almost all the evidence adduced by UJ and taken into account by the High Court was plainly inadmissible on the basis of the parole evidence rule. This was so because while it was admitted under the guise of establishing context, the evidence was in fact introduced to add to, vary, or contradict the general words of the lease, which did not prohibit cession. The Supreme Court of Appeal noted that the lease contained a whole agreement clause to the effect that the lease was intended to be the sole memorial of the agreement between the parties. It held that since the terms of the lease were unambiguous, the High Court ought to have had regard only to the words used, which should have been construed objectively. According to the Supreme Court of Appeal, there was nothing in Clause 8 or any of the other terms of the lease which justified that the conclusion that the rights were personal to ATS and incapable of cession. The court therefore upheld the appeal with cost and replaced the order of the High Court with an order dismissing UJ's claim. Before this court, UJ submitted that the Supreme Court of Appeal's conclusion that the lease could not be delectus personae because nothing in the lease itself showed that the rights were intended to be personal to ATS, conflated the delectus personae concept with the other mechanism by which a creditor may be prohibited from ceding a contractual right without the debtor's consent. That is, where there is a term in the contract prohibiting cession, often referred to as pactum de non cedendo, on which UJ's case has never been based. According to UJ, the Supreme Court of Appeal erred by failing to have regard to the context of the lease. UJ submitted that this was inconsistent with the Supreme Court of Appeal's contextual approach in its prior case law on the interpretation of contracts, and effectively means that the doctrine of delectus personae will never again find application because courts will no longer be able to consider context when assessing whether rights are personal. UJ maintained that the evidence it led was admissible to shed light on the nature of the rights and clearly showed that it makes a significant difference to UJ whether the person in whom the rights are vested under the lease agreement is ATS or WOMJ. According to UJ, the cession to WOMJ defeats the purpose of the lease agreement, as ATS will no longer be able to meet its obligation under the lease to construct a theological college, which is prejudicial to UJ. UJ maintained that in purporting to cede rights personal to it, ATS repudiated the agreement, which entitled UJ to cancel the lease, and submitted that the decisions of the High Court and the full court were therefore correct. UJ requested the Constitutional Court to uphold the appeal with cause. The respondents opposed UJ's application for leave to appeal to the Constitutional Court. The central argument advanced by the respondent was that UJ and not the Supreme Court of Appeal conflated the concept of pactum de non cedendo with delectus personae by seeking to engage in a process of contractual interpretation. The respondent submitted that the nature of the right in this case was easily capable of determination from a plain reading of the lease agreement, and was simply the beneficial occupation of the land and the rights that flow therefrom. They argued that the Supreme Court of Appeal was correct in finding that the contextual evidence adduced by UJ was inadmissible, as there was no term in the contract that required interpretation once the nature of the right could be ascertained from the plain reading of the lease. The respondent submitted that rights under a lease can be without the consent of the landlord, as there is ordinarily no delectus personae for lessors. They argued that the cession did not alter the characteristics of the performance owed by UJ, which was merely to provide beneficial occupation, just because the creditor changed from ATS to WOMJ. Therefore, the rights flowing from the lease could not be delectus personae and were freely capable of cession. Finally, the respondents argued that even if the UJ succeeded in showing that the rights were personal, ATS cannot be said to have repudiated the lease because ATS conduct falls far short of an intention not to be bound by the lease. The respondents also raised the defenses of waiver and estoppel and submitted that the appeal should be dismissed with cause. The Constitutional Court, in a unanimous judgment penned by myself, entertains the appeal on the basis that it raises arguable points of law of general public importance which ought to be decided by the court. It holds that when courts interpret contracts, they are enjoined to follow the now settled unitary approach to contractual interpretation set out in previous decisions of both the Constitutional Court and the Supreme Court of Appeal. The approach requires courts to have regard to the context of a contract, whether or not the words used in the contract are seemingly clear and unambiguous. The Constitutional Court further holds that the injunction on courts to have regard to context when interpreting a contract does not change when the purpose of the interpretive exercise is to determine whether the rights flowing from the contract are delectus personae. Nor should courts shy away from considering context merely because the contract being interpreted contains a whole agreement clause. This is so because the obligations on courts to take a contextual approach to contractual interpretation is peremptory and therefore incapable of exclusion by agreement. To the extent that the Supreme Court of Appeal in this matter excluded evidence of context on the basis that the terms of the lease were clear and ambiguous, and because the lease stated that it was the sole memorial of the agreement between the parties, the court erred. This court finds that the contextual evidence is relevant when a court determines whether rights in a contract are delectus personae. This is so because courts must determine the true nature of the rights flowing from the contract by undertaking the unitary exercise of interpreting the contract in light of its factual matrix, its purpose, the circumstances leading up to its conclusion, and the knowledge at the time of those who negotiated and produced the contract. Therefore, the respondent's contention that rights under the urban leases are generally not delectus personae cannot simply be the end of the inquiry. While certain rights may generally be of a certain nature, the authorities on delectus personae show that the question of whether they are personal will always depend on the proper interpretation of the contract in light of its circumstances. The Constitutional Court holds that while rights in a long-term lease are not ordinarily delectus personae, it is clear from our law that such rights can be personal if the nature of the contract, properly interpreted in light of its circumstances, establishes that they are personal. The inquiry in all cases is simply whether the rights flowing from the contract in question are so personal in nature that it makes a reasonable or substantial difference to the lessor whether the lessee or the intended cessionary is entitled to enforce the rights. It finds that in this case, contextual evidence sought to be adduced by UJ was rightly permitted by the High Court in order to undergo a proper contextual interpretation of the lease and Clause 8 in particular, so that the nature of the rights flowing from the lease could be determined. The evidence was not precluded by parole evidence rule because it did not seek to add to, vary, modify, or contradict the term of the lease. Rather, it gave necessary context and background to the lease. This court cannot fault the findings of the High Court and the full court in their conclusion that the rights under the lease were delectus personae based on the circumstances of this case. The existing personal relationship between the parties, the statutory framework, and the ministerial permission on which the conclusion of the lease was based all point to the personal nature of the lease. The court concludes from the evidence that the land was leased to UJ as the helping hand. It could never have been intended by the parties at the time of conclusion of the lease agreement that ATS could simply cede its rights to use the land to another in exchange for profit. The rights were personal to ATS and therefore incapable of cession by virtue of the delectus personae doctrine. The Constitutional Court finds that ATS repudiated the lease by purporting to cede rights which were personal to it in terms of the lease. Given the very personal nature of the rights under the lease and the specified use of the land to build a theological college, it was reasonable of UJ to believe that ATS conduct of ceding the rights to another institution, which would be unable to use the land in accordance with the lease, communicated that ATS intended to no longer be bound by the lease. The court finds that the repudiation was serious enough to entitle UJ to cancel the lease. On the defenses of waiver and estoppel, this court finds that these defenses, which were not sufficiently ventilated in both written and oral argument, were last chance attempts by the respondents not to be held responsible for unlawfully attempting to cede rights that were not transferable, and in so doing, profiteering handsomely at UJ's expense. In the premises, the Constitutional Court grants leave to appeal to UJ and upholds the appeal. The court finds no reason why courts should not follow the result. The Constitutional Court therefore makes the following order. 1, leave to appeal is granted. 2, the appeal is upheld. 3, the order of the Supreme Court of Appeal is set aside and replaced with the following order that, I quote, the appeal is dismissed with close quotation. 4, the respondents are ordered jointly and severally to pay the cost of the applicant in this court, including the cost of 2 counsel. I hand down the judgment.
As the
Judgment,
court pleases.
Court pleases.
judgment will be emailed to the parties and will be available online on platforms such as Safely. Today's proceedings have concluded. The host will now terminate the meeting.
Thank you. The meeting is adjourned.